The recent decisions by the U.S. Supreme Court are getting a lot of attention this week. One in particular, the decision to side with a Colorado cake maker who would not bake a cake for a same-sex wedding. Spectrum News 13's Eric Levy sat down with a local professor to discuss this ruling in depth.
It's been getting a lot of discussion. Terri Day, professor of law at Barry University, joining us to go in depth about it. Thanks for coming in.
Thank you for having me.
So essentially, what does Monday's ruling mean? Let's talk about it.
Yeah, it doesn't mean very much. It is, the court has taken a controversial issue, decided it on a very narrow basis that is really pertinent only to the facts of the case before it.
And I've seen chatter on social media, some upset, some disappointment, if you will, from the LGBT community. This is not, this is not anything that's going to really affect the community.
No, this ruling will not apply to other cases. The issue with this case is the court said that the Colorado Civil Rights Commission that hears these public accommodation violation complaints treated Mr. Phillips' religious beliefs and religious reasons with hostility.
And let's talk about, because we'll go a little bit further into this, the fact that there is no precedent set here. One of the justices, in fact, on Monday said that this outcome is for this case.
Right.
Other cases like this may have a different outcome. It's a term case-by-case basis.
Exactly. And again, because of the particular facts in this case, that's why the ruling was the way it was. The commission showed hostility towards religion, and government, in this case the commission, cannot show hostility towards religious beliefs. That violates the Free Exercise Clause.
And we can talk about that a little bit more in general, the argument over religious freedom.
Yes. Well, sometimes religious beliefs must give way to application of neutral laws of general applicability. So the state's interest in anti-discrimination and applies neutrally and generally to all businesses that are covered by the public accommodations law. It means that individual religious beliefs may at times have to give way to the state's interest in anti-discrimination. Okay,
so let's talk about now about the Constitution, the broad perspective. It only protects citizens against hostility from government, not from fellow citizens?
That's true, but when government makes rulings, in this case, the Colorado Commission on Civil Rights is an arm of the state, and then the Colorado Court of Appeals, and then the U.S. Supreme Court. So you have government entities making decisions in the case, which is sufficient for government action.
Okay, so in what is the next step, if anything?
Yeah, well, the next step will be another case, I presume, that makes it to the U.S. Supreme Court. But the U.S. Supreme Court has to grant certiorari. It's discretionary whether or not the court will hear a case. It's noteworthy that there have been several state cases, and 3 or 4 state Supreme Courts have basically upheld the right of same-sex couples not to be discriminated because of a flower arranger, a videographer, a photographer, individual moral beliefs against same-sex marriage.
All right. Well, Terri Day, thank you very much for coming in. I know you have a little laryngitis, but I appreciate you using some of your voice to go in depth about this. It's a very, very important topic, and one that's going to be talked about for a while. And like you said, no precedent set here.
Right.
It's the case-by-case basis.
Right. Thank you for having me.
All right. Terri Day, professor of law at Barry University. Thanks for coming in.
Thanks.